Deputy McLeish, are we missing some light bulbs out there? It looks pretty dark.
It's a new feng shui of the jail, Your Honor.
Feng shui, I like it. It's all about food these days. All right. Court is in session, and we're going to call the afternoon docket, and we're going to begin with Mr. Adams. Mr. Adams, who do you have here? Is this Adam Joslin?
That's correct, Your Honor.
All right, Mr. Joslin, this is cause number CR 21329, 2022-75. We are set for pretrial on one and status. It looks like motion for CPS records on the sexual assault of a child case. Go ahead, Mr. Adams.
Yes, Your Honor. Pardon me. Grab this one. Judge, just recently, as we discussed at our last pretrial hearing, I did file a motion for discovery tailored or targeted at potential investigatory records from the DFPS. I filed that motion under Chapter 261 of the Family Code. I tried to make that motion as narrowly tailored in time and scope as possible. Specifically, the motion is asking for any records regarding Casey Doreen Thompson, date of birth November 6, 1984, who is the mother of the alleged victim in this case, that might have been generated between January 1st, 2015 and July of 2018.
Okay. Have you consulted with the state about this, or is it just the motion?
Yes, Your Honor.
In fact, because of Ms. Heisel and I talking about this specific issue, that the dates are what they are, and the requested dates are what they are in that motion.
And Judge, I don't have a copy of Mr. Adams's motion yet. It's very possible that it is still in the DAE file email and just hasn't been forwarded to me. But I'll make sure I get that either from the clerk or I'll check with Ms. Abney about the DAE file email. And we will be sending out a subpoena for those records to DFPS.
Okay, so the state wants the court to go ahead and grant the motion, or do you want me to withhold granting the motion until you have a chance to read it?
Your Honor, I'm comfortable based on Mr. Adams and I kind of negotiating what was going to be requested. Everything he's put on the record is what we've already discussed. So I'm comfortable with the court going ahead and granting that. I suspect that once the state receives those records back from DFPS, we will then file for in-camera review of those. That's kind of the timeline. They typically can get back to us within 30 days once we've issued a subpoena. So it's up to the court when you want to set this for status.
Okay, court will grant the motion for CPS records filed by Mr. Joslin. The court will set this for a status on CPS records. Are you available on either July 19th or 21st, Mr. Adams?
Yes, sure, Your Honor. Either day is fine.
All right, court will set this hearing on July 19th at 1:30.
Hillary, I will fax over the motion to you this afternoon, just so you have it. It won't have a file number on it, but you'll have it.
Sounds good. Thank you.
Judge, on the other matter, we don't have any pretrial issues to take up today.
Okay. All right, court will set it for the docket call on that same date, 7/19.
Very good.
All right, thank you, Mr. Joslin.
Your Honor, that's all I have, I think, this afternoon.
Yes, thank you, Mr. Adams.
All right, thank you.
All right, Mr. Knoll, who are you ready on?
Judge, I think first we need to take up Mr. Ibarra, and then we would have a plea with Mr. Gilliland after that.
All right, Arthur Ibarra, come forward, sir. CR 22-159 at 160, set for arraignment. Mr. Knoll, are you ready for arraignment?
Judge, I am. All I can tell the court is I think Mr. Ibarra believes the old code section that said if you're not indicted in 180 days, King's X on that, that doesn't apply anymore, hasn't been in effect for decades. And certainly the statute of limitations has not run on either case. They are both possession cases. One alleges possession with intent to deliver. That case is a first degree felony, range of punishment, obviously 5 to life. The other is a second degree, same, more than 4, less than 200 grams. However, there is no allegation of with intent to deliver. He has indicated to me that his name is spelled correctly. I would assume for the purposes of arraignment, we would be entering a plea of not guilty.
All right, court will enter Mr. Ibarra's plea of not guilty to the record in each cause. We will set these matters for pretrial hearing.
Judge, I actually got everything to this state. I think I have everything with the exception of lab reports on both cases. I've got videos and all of the rest of it.
Okay, good. All right, looks like you're coming back on July 5th. Any opposition to setting these for pretrial on July 5th?
I have none.
All right, court sets each case for pretrial July 5th, 1:30 if Mr. Ibarra is in jail, of course, 9 a.m. if he is on bail. All right, Mr. Gilliland, if you will come forward, please. CR 22-134. Mr. Knoll, you said that we're going to have a plea on Mr. Gilliland. Is that correct?
That's correct, Judge.
All right, I show him set for arraignment, and I don't see if I have. Well, I do. Actually. Go. All right, this is.
Judge, I want to thank the jail staff. They actually let me in here before 8 o'clock this morning to review stuff, and that was one of the reasons why we were able to resolve this today with obviously the help of the state.
Excellent. Thank you. I'm glad to hear that. All right, Mr. Gilliland, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Thank you, sir. You may put your hand down. Is your name Zachary Wayne Gilliland?
Yes, sir.
And Mr. Gilliland, are you a United States citizen?
Yes, sir, I am.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Kurt Knoll. Are you pleased with his representation of you?
Yes, sir, I am.
You feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read today and signed with his assistance that you do not understand?
No, sir.
Mr. Knoll, do you believe your client to be competent?
I do, Your Honor.
And have you explained to him his legal rights as they pertain to these cases?
I have.
And you believe he understands all of his legal rights?
I believe that he does.
It appears that Mr. Gilliland, you have been charged by indictment with a third-degree felony offense of unlawful possession of firearm by a felon, which does carry a range of punishment if convicted and sentenced to not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice and possible fine up to $10,000. I see that the plea agreement in this case is that you would plead guilty to that charge. The state would be recommending that your punishment be assessed at 8 years confinement in TDC with a $1,500 fine plus court costs and restitution and reimbursement fees you would receive 182 days credit towards that sentence. Also, the state would dismiss several cases. It appears a burglary of a vehicle, a theft of property, $2,500 to $30,000, criminal mischief, driving while license invalid, and also an accident involving damage to a vehicle. Is that your understanding of the plea agreement, sir?
Yes, sir.
And that's what you want the court to approve?
Judge, if I could, the court may have missed, since it's felon in possession of a firearm, it also has an enhancement paragraph. In other words, we have the predicate offense of theft of property that was a felony. And then there's an enhancing paragraph, which I believe my client would also enter a plea of truth to also.
Okay, well, the judgment doesn't reflect that. The judgment reflects a third-degree felony. It does not have any kind of findings on the enhancement paragraph. So I see what you're saying about the indictment saying enhanced to second degree, but the judgment that I've been provided says third degree with no enhancement.
Okay.
So what's y'all's agreement? What do y'all want to do?
Judge, the state's offer to Mr. Gilliland falls within both ranges. At this point, the state would be willing to abandon the enhancement paragraph and allow him to plead to 8 on a third degree.
Mr. Nelson?
We're happy with that. The court would also strike that from the court's copy so that the record's clear all the way around, and we're taking it off the plea papers and doing initials.
Okay. So just for the record, to be clear, Mr. Gilliland would be pleading guilty to a third-degree felony, unlawful possession, firearm by a felon, with the same recommended punishment, 8 years confinement, TDC.
That's correct, Your Honor.
Okay. All right. So,
I'm
Mr.
sorry,
Nolan, go ahead.
that's my understanding and Mr. Gilliland's understanding at this point.
All right, Mr. Gilliland, how do you plead to unlawful possession of firearm by a felon?
Guilty.
You're pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, court accepts the defendant's plea of guilt. Mr. Nolan, any objection to State's Exhibit 1?
No, Your Honor.
All right, State's Exhibit 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close at this time.
From the defense?
No, Your Honor.
All right, court will review the evidence briefly. All right, court's reviewed the evidence. I do find enough evidence to convict Mr. Gilliland of this offense. The court will follow the plea agreement. Court hereby convicts Zachary Gilliland of unlawful possession of firearm by felon. Assesses his punishment at 8 years confinement in the Texas Department of Criminal Justice Institutional Division. Court orders him to pay a $1,500 fine. Restitution in the amount of $2,608. Court costs $290 and reimbursement fees of $20. And the court will dismiss DA 2022-27, burglary of a vehicle, DA 2022-25, theft of property, DA 2022-26, criminal mischief, DA 2021, driving while licensed invalid with previous conviction, and 2022-74, accident involving damage to vehicle. Court awards Mr. Gilliland 182 days credit towards the sentence for the time that he has spent in jail on this cause. Mr. Gilliland, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. You'll go over with the deputy to be fingerprinted. Good luck to you, sir.
Thank you.
Good, that's all I have. Now be excused.
Yes, thank you, Mr. Knoll.
Thank you, Judge.
Your Honor, Mr. Gimble's going to make an announcement on Zachary Verde.
Okay.
Afternoon, Your Honor.
Good afternoon, Mr. Gimble. This is cause number CR 2148, State versus Zachary Verde. Show that he's been confirmed in Rockwall County still.
That is my understanding, Your Honor.
Do you know what he's charged with up there?
I do not know. I just became aware today that he was located in Rockwall.
Attachment. Oh, here we go. Let's see what it says here. If anything. Oh, let's see. Looks like it's going to be possession of controlled substance related. Shouldn't be any surprise to us. Okay, all right, the court will reset this case for a status of his custody. Court will reset this to, are you available on either July 19th or 21st, Mr. Gibble?
Either one of those days I'm open, Judge.
Right, we will set this for Thursday, July 21st at 1:30. And Mr. Gimble, if you know that, if you don't have any other business in Van Zandt County on that day, and if Mr. Byrd is still confirmed in custody somewhere else, then just let my coordinator know and we can have you appear Zoom and save you a trip.
Thank you, Your Honor.
You're welcome. All right, Ms. Tabram, who do we have next? Or Deputy Police, whoever.
So that's gonna be Mr. Stevens.
On Miss Doby.
All right, this is cause number CR 22-130 and 131, State versus Shane and Doby. Good afternoon, Mr. Stevens.
Afternoon, Your Honor.
All right, I show that we are set for arraignment. Mr. Stevens, have you had an opportunity to go over the indictments with your client?
Yes, I have, Your Honor.
All right, are you ready to proceed?
Yes, Your Honor.
All right, go ahead.
Defendant would waive arraignment, waiving the indictments. She voluntarily entered a plea of not guilty on both cases. She understands the range of punishment on both cases and the alleged offense.
All right, court will find that Ms. Doby has waived the formal requirements of arraignment. Court will enter her plea of not guilty as to each charge into the record. And Mr. Stevens, do you have your calendar available so we can set a pretrial date?
Yes, Your Honor.
All right, so got a couple dates available in July. I've got July 5th, 7th, 19th, or 21st.
I know the 5th isn't good, Your Honor.
I'm sorry, say that again.
I know the 5th is not good. I'm just double checking on the other days. What were the other dates, Your Honor?
7th, 19th, 21st. While Mr. Stevens is looking, State, can you confirm whether or not Mr. Stevens has gone through the process to be set up for electronic discovery so he can receive the state's file?
Your Honor, I believe they are in the process. Ms. Melton is currently copying discs, and I believe that the information has been sent to Mr. Stevens for the portal. I don't know that we've successfully completed that task, but we are in communication and working towards that.
Yes, Your Honor, I dropped off discs this afternoon to be copied, and we have in the process of setting up access on the portal.
Okay.
The 19th or 21st is fine, Your Honor.
Okay. All right, then we'll set this for Thursday, July 21st for pretrial. Of course, any pretrial motions that need to be filed, Mr. Stevens, need to be filed 7 days prior to that date. Any pretrial motions that need a hearing, such as contested motions, motions to suppress, quash, things of that nature, where we're gonna have evidence, they won't be heard on that day, but they'll be taken up on that day.
And what time was that, Your Honor?
The jail docket's always called in the afternoon, and the bail docket's always called at 9 a.m. So if your client's in jail, it'll be 1:30. If she makes bail, it'll be at 9 a.m.
Okay, thanks, Your Honor.
All right, you're very welcome.
Your Honor, do you see the Spanish interpreter?
I do. Are we ready?
Yes, sir.
All right, I'll bring in Mr. Vargas.
Morning, Judge.
Good morning, Mr. Hindi. How are you, sir?
Good, sir. How are you?
I'm doing great. All right, Mr. Vargas, everything like a go on your end? All right, this is cause number CR 21233, State versus Yondus, Omar, Perez, Hidalgo. And at this time, Mr. Vargas, as the court's interpreter, I'm going to ask that you identify yourself for the record, and I'm going to place you under oath. And you'll have to come back to the English channel. Okay, there we go. All right, can you go ahead and identify yourself and your license number for the record? All right, Mr. Vargas, if you'll raise your right hand. Sir, do you solemnly swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? All right, thank you. Mr. Abraham, are we set up with the Spanish channel?
Yes, sir.
All right, Mr. Vargas, I'll give you a moment, and if you'll want to make sure that Mr. Perez can hear you. You'll need to, Mr. Vargas, you'll need to go to the Spanish channel.
Sí, ahora sí.
Okay, excellent. All right. So, Mr. Hindi, what's the announcement for the defense today? We're set on a hearing on the motion to revoke.
Yes, Judge. I had reached out to the prosecutor via email before I went out of town. I know that she had not received the formal motion yet. So I have not received a recommendation from the state yet. I was waiting on that to see if we could dispose of it today or whether we needed to pass it for a contested revocation or whatnot.
And Your Honor, I do have the report. I have not made an offer yet, but if we set it for the contested docket by the end of the month, I'm confident that we will either have it worked out that day or be ready to go to a hearing on that day.
Okay. Court will set Mr. Perez for either a disposition or a contested hearing. Actually, we won't be able to set it on. Won't be able to set it on. Well, I'll tell you what. We'll do this. We'll set it in the morning of June 28th at 9 a.m. And we'll have, of course, Mr. Perez brought over to the courthouse, Mr. Hendy, so that everything will be in the courtroom on that day.
Yes, sir.
Okay. All right. So if we reach an agreement, we can resolve it that day. If we don't, then we'll move forward with a contested hearing.
Yes, Judge.
All right. All right. If there's nothing further, then we'll be adjourned in Mr. Perez's case.
Thank you, Your Honor.
You're very welcome. Yes, sir. I believe set at 2:30 with Mr. Manning and Jose Romero. Okay. Yeah. And if you have other hearings you need to go to, I don't know. Ms. Abraham, is Mr. Manning and his client ready? Do they want to go earlier?
No, sir, they're still, I think Mr. Manning is going over paperwork with.
Yeah, and I can't hear you. 2:30. Okay. All right. Sorry about that, Ms. Vargas.
Your Honor, can you hear me?
No, you're very muted. I don't know. Are you in the English channel or Spanish channel? I can hear the clicking better now. Can you say something, Aaron?
How about now?
Yes, that's excellent now.
Okay, very good. Mr. Manning is working on paperwork with other clients. He's not even in the room right now.
Okay.
We have Mr. Schmidt with 2 of his clients available.
Ready to go. Thank you, Mr. Vargas. Appreciate you, sir. Who are you ready on, Mr. Schmidt?
I'm ready on Courtney Schmucker and Jennifer Culpepper.
Okay. Courtney Schmucker, CR 21241 for arraignment.
We're prepared to move forward with the plea on this Schmucker. We've completed the paperwork and are ready to ride.
Okay. Let's see if I have them here. I don't believe I have paperwork from Ms. Schmucker, so can you go ahead and give me the terms of the plea agreement, Mr. Schmidt?
Yes, sir. In exchange for a plea of guilt, the state's recommending that Ms. Schmucker's punishment be assessed at 3 years in TDC and a $2,500 fine, DPS, restitution, court costs. In addition to that, Judge, we're pleading to a lesser included possession, 4 to 200, which is a second-degree felony. And the state is going to take under 1245, the Texas Penal Code, several other offenses that they have pending and unfiled, ultimately completing her business in Van Zandt County.
Okay. So I won't be pronouncing those on the record, so that will only be on the judgment if I don't have those.
That's correct.
Court cost is $290. I'm assuming restitution $180.
That's correct.
All right. And does she have any credit time?
83 days. There's also a reimbursement fee of $83 that's broken out of the cost.
How much? $83?
Well, I'm sorry, $85.
$85?
Yes, sir.
Reimbursement. Okay. Okay. All right, Ms. Schmucker, if you will, raise your right hand for me. I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may put your hand down. All right, your name is Courtney Ray Schmucker, is that correct?
Yes.
And Ms. Schmucker, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Schmidt, do you believe your client to be competent today?
I do, Judge.
And we were set for arraignment on Ms. Schmucker's case. Do you believe that she has taken enough time to review the evidence in this case and move forward directly with a plea?
Judge, she and I discussed that and her options, and we're prepared to move forward. Yes, sir.
Okay. All right, Ms. Schmucker, you are charged by indictment with a first-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1, 4 grams to 200 grams. The plea agreement in this case that you heard Mr. Schmidt state is that you would plead guilty to a lesser included charge, a second-degree felony offense of possession of controlled substance between 4 grams in penalty group 1, between 4 grams to 200 grams. And you heard the plea agreement as stated by Mr. Schmidt, is that correct?
Yes.
And that's what you're asking the court to approve today, is that right?
Yes, sir.
And you understand that the range of punishment for a second-degree felony offense is minimum 2 years in prison to a maximum 20 years in prison and a fine not to exceed $10,000. Is that right?
Yes, sir.
Okay. You understand the range of punishment and you seem to understand the plea agreement. You're still wanting to go forward at this time?
Yes, sir.
All right, Ms. Schmucker, how do you plead to possession of a controlled substance in penalty group 1 greater than or equal to 4 grams, less than 200 grams?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
The court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to state's evidence?
No, Judge.
State's evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we'd rest and close at this time.
Mr. Woodwhite, can you go ahead and give me the summary of facts that will support this plea?
Yes, Your Honor. On the date in question, the defendant is pulled over by the Highway Patrol for speeding, going 86 in a 75. DPS notices the odor of marijuana in the vehicle. There's a number of the car is very filled with items. Highway Patrol asks if there's anything illegal. Defendant states there's some marijuana and hands him a marijuana cigarette. Highway Patrol goes to do a probable cause search. Defendant then admits to more marijuana and a grinder in a safe inside the vehicle. Inside the safe is a number of paraphernalia, marijuana, rolling papers, items of that nature, and heroin that the lab tests to 7.63 grams.
Thank you, Mr. Woodwhite. Mr. Schmidt, any objection to that summary or additions or deletions?
No, sir. We are good.
All right, then based on the evidence as presented to the court will, and I'm sorry, Mr. Schmidt, anything further on behalf of the defense?
Nothing further.
Okay. Then based on the evidence, the court does find that there is sufficient evidence to convict Courtney Ray Schmucker of possession of controlled substance in penalty group 1 greater than or equal to 4 grams, less than 200 grams. The court does convict her this date of that crime. The court does impose a sentence pursuant to the plea agreement at 3 years confinement in the Texas Department of Criminal Justice, orders her to pay a $2,500 fine, $290 court cost, $180 reimbursement fee, $180 restitution fee to DPS, orders her to pay $85 reimbursement fee, and awards her 83 days credit towards her sentence for the time that she has spent in jail on this cause. The court will dismiss under section 1245 those extraneous offenses laid out in the judgment in this cause. Mr. Schmucker, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Go ahead and step over with the deputy. Good luck to you. All right, Mr. Schmidt, who are you ready on now?
Judge, I've got Nathan Sampson, Amanda Meek, or Ms. Culpepper here.
Okay, we'll go with Nathan Sampson, CR 2135. All right. Mr. Sampson, is he entering into a plea agreement with the state today?
Yes, sir.
All right, Mr. Sampson, if you will, sir, raise your right hand so I can place you under oath. Mr. Sampson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may put your hand down. Mr. Sampson, are you a United States citizen?
Yes. You're here? Well, let's-
Yeah. Just come on up if you need to. Mr. Sampson, can you hear me now?
Yeah.
Okay. Are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
With a mental condition. Oh, no.
In this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation of you?
Yes.
Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes.
Is there anything about the paperwork that you've read and signed today that you do not understand?
Yes.
So you're clear on everything. You understand everything you signed. You don't have any questions. Is that right? I'm sorry, I couldn't hear you.
Yes.
Okay. Mr. Schmidt, do you believe Mr. Sampson to be competent today?
I do, Judge.
You've explained his rights and evidence to him in this case, and you believe that he understands them?
Yes, sir.
All right, Mr. Sampson, you are charged by indictment with a third-degree felony offense of possession of child pornography, which carries a range of punishment of not less than 2 years or more than 10 years confinement in prison, and an optional fine not to exceed $10,000. Do you understand that range of punishment?
Yes.
All right, Mr. Schmidt, can you tell me what the plea agreement is in this case?
Judge.
Sorry.
this is subject to
Okay, Richard's got it covered.
We're actually proceeding on the state's motion to revoke community supervision. In this case, the plea agreement is to plead true to the account, revoke community supervision, sentence Mr. Sampson to 5 years in Texas Department of Criminal Justice in order that he pay the balances of his financial obligations. Along those lines, Judge, we do have and have reviewed a copy of the state's motion to revoke community supervision. So from that perspective, we'll wait for more reading and we'll proceed to plead true on counts 1, 2, and 3.
All right, thank you, Mr. Schmidt. I was unaware that it didn't reflect on my docket that it was a motion to revoke, and I just did not have that recollection. Okay, so Mr. Sampson, I'm going to ask you, have you had sufficient time to review the motion to revoke with Mr. Schmidt?
Did you understand the question? He's asking you if you have enough time to talk to me about this. Oh, yes.
Okay, and it's your intent to plead true to counts 1, 2, and 3 in that motion. Is that right? Can he not hear me, Mr. Schmidt?
No, Judge, we've got a lot of background noise. Mr. Sampson's a little hard to hear him.
I think it was just motion to revoke.
Yeah, that's what we're being true to. So counts 1, 2, 3 in the state's motion is what he's asking. Okay, 1, 2, and then, yeah. So he's going to ask you if those are true or not true. He's asking if you intend to be true to those. What do you have a question?
So there's more counts. There's three
No,
counts.
there's only 3. That's the entirety of the motion.
For the fact.
Yeah, to revoke your probation.
Yes.
Okay. And Mr. Schmidt, what's the credit time that he would be given?
185 days, Judge.
All right, just so it's plea true to counts 1 through 3, revoke 5 years TDC, balance of financials, credit time 185.
That's correct.
All right, Mr. Sampson, at this time, I'm going to ask you, how do you plead to counts 1, 2, and 3? Are those counts alleged in that motion true or not true?
True.
True. And are you telling me that each one of those is true because what's alleged is true? You're not just telling me that they're true so that you can get a plea agreement. Is that right?
No.
Okay. All right. And has anyone threatened or forced you to make you feel like you had to plead true today to any of those counts?
No.
Okay. All right. Court will accept the defendant's plea of true to counts 1, 2, and 3. Any objection to the admission of the defense waiver of rights and plea of true, Mr. Schmidt?
No objection.
All right. Those are admitted. Court does take judicial notice of Mr. Sampson's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
Nothing further.
All right. Based on the defendant's plea of true and the evidence admitted, the court finds that Mr. Sampson has violated the terms and conditions of his community supervision. Court finds counts 1, 2, and 3 to be true. Court hereby revokes Mr. Sampson's community supervision, assesses his punishment at 5 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay the balance of his financial obligations, and awards him 185 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Sampson, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I will have you step over to be fingerprinted with the bailiff at this time. All right, let's see. Amanda Meek, CR 2218.
Amanda?
All right, Ms. Meek, this is a hearing on her motion to revoke.
Judge, it is, and I was made aware of Ms. Meek's case yesterday. Obviously, we're not ready to proceed. I'd ask that the motion to revoke be reset to that July 19th date.
Any objection from the state?
No, Your Honor. This is brand new.
All right, court will set Ms. Meek's case to July 19th at 1:30. So long as she's in custody, if she's on bail, it will be at 9 a.m. I believe this is a motion to revoke. Is it a motion to revoke or motion to adjudicate?
Revoke, I understand.
Okay, so it'll be at 1:30. Ready on anyone else? Mr. Schmucker?
Judge Culpepper for an arraignment.
Ms. Culpepper, CR 21352. Ms. Culpepper is set for arraignment today on a 3rd-degree possession of controlled substance.
That's correct, Judge. I've received a copy of the indictment. I've discussed it with Ms. Culpepper. At this point in time, her name's spelled correctly. We've waived formal reading, enter a plea of not guilty, and ask it set for that July 19th pretrial date.
All right, court will enter Ms. Culpepper's plea of not guilty into the record, and the court will set this matter for pretrial hearing on July 19th at 1:30. Ms. Culpepper, if you make bail in this case, your hearings will be at 9 a.m. in the morning at the courthouse.
Yes, sir.
Mr. Wayne. Yeah. Yes, sir. Yes, sir.
All right, who do you have with you, Mr. Schmidt?
This is Bobby Land, CR 18-145.
Land, L-A-N-D.
Correct, sir.
Oh, here, okay, top of page 5. Okay, all right, Mr. Land is set on motion to revoke. I'm assuming you just got appointed, Mr. Schmidt.
That's correct, Judge. And I've explained to Mr. Land that we're going to ask the court to reset this matter for July 19th at the 1:30 docket. Give us an opportunity to meet with the state.
All right. Court will set this for a hearing on the motion to revoke July 19th. And let's go ahead and set it also for July 26th. If there's no resolution on the 19th, then we'll set it also for evidentiary hearing, contested hearing on 7/26.
Yes, sir. I'll try to do that. Yes, sir. Yes, sir. Thank you.
Do you see Mr. Vargas back, Judge?
No, ma'am.
Okay, if you'll
He
just let
won't.
me-
2:30, he said he'd be back at 2:30.
Okay, they're both in here, so whenever you see him.
Okay.
Thank you, sir.
Your Honor,
Yes, ma'am.
while we wait, I do have Mr. Crane here to speak with you about Mr. Gutierrez. I don't know if you need Mr. Gutierrez present in
I
here.
do.
If you want.
Yeah, I need Mr. Gutierrez in the courtroom. Yes.
Would you read the text that I sent you, please?
No, I have not.
Your Honor, may I?
Okay, all right, I've reviewed. All right, so court will call CR 2168, State versus Adrian Gutierrez. Go ahead, Mr. Crane.
Yes, basically, we both just want to be untied. He doesn't want me as his lawyer, and I don't want him as my client anymore.
Mr. Crane, are those sunglasses?
They're reading glasses, but yes, the ones I grabbed this morning, sir. I don't need to read right now.
So the problem I have is that it seems that Mr. Gutierrez has some issues that concern the jail about his stability. So
Yes, I would not be able to testify that he's competent. Not at this time, not since the last time I saw him.
right, so I would need him to be able to be involved in the hearing so I can hear whether or not he also wants to be untied, as you say. So what I can do is I can reset this case and we can see what his mental stability is here in 30 days or so. And if he gets worse, if you think he's incompetent, then you can file a motion with the court and we can have him evaluated. But unfortunately, I'm not willing to grant a motion to withdraw until I have the defendant able to tell me that he no longer wants you as his attorney.
I understand, sir, and thank you for your consideration.
Right. Do you have your calendar available? Could you be available on either July 19th or 21st?
At 1:30?
Yes, July 19th or 21st at 1:30.
The 19th at 1:30.
Are you available on either of those days, the 19th or the 21st?
Yes,
Okay. Do you prefer one over the other?
yes,
Which one do you prefer?
the 9th.
The 19th?
Yes,
Okay. Court's going to set Mr. Gutierrez for July 19th at 1:30. And we'll set him for a status on his competency on that date. All right, Mr. Crean?
yes, sir, and I'll file a motion to have his competency evaluated.
All right. Thank you, sir. I appreciate it.
Thank you, sir. You have a nice day.
Yeah, and Mr. Crane, make sure you support that with an affidavit.
Yes, sir, I will.
Thank you. Appreciate it.
You're welcome.
Your Honor, would you like to get Mr. Schmidt and his final line in front of you, or is the interpreter ready?
Interpreter's not here, so yes, Mr. Schmidt.
Okay, thank you.
This is Garrett, Joslin, CR 22-149.
All right, Mr. Joslin set for arraignment today. Are you ready to go forward with arraignment, Mr. Schmidt?
We are ready to go forward, Judge. I've received a copy of the indictment. Mr. Joslin's name spelled correctly. He understands what he's charged with. We'll wait formal reading and plead not guilty. Ask for that July 19th pretrial date.
All right, court enters Mr. Joslin's plea of not guilty into the record, finds that he's waived formal requirements of arraignment. Court sets pretrial July 19th.
Thanks, sir.
Mr. Schmidt, do you, you also have Robert Campbell, is that correct?
Robert Campbell.
Yeah, I show him on the docket under you.
Oh, Horton. You're talking about Horton.
No, I'm talking about Robert Baker Campbell, CR 19108, on my page 8, but right before.
That was the one that was read.
Judge, basically, I think yesterday it was Jonathan Manning's. Today it's mine, or maybe that happened yesterday. So I didn't catch that it was on the docket day, but I'm sure I was told. And that's obviously going to be an MTR.
Is he in the courtroom at all?
I don't know.
We had to amend that order, Judge, because of a conflict that Mr. Manning had.
Okay, so do you all want to bring him up or not? I just want him to be aware that counsel has been appointed and that we can reset it for July 19th.
Judge, if it pleases the court, I'm going to meet with Mr. Campbell tomorrow morning here at the jail. And if we're going to set it for July 19th, rather than bringing him up, I'll inform him of that in the morning. Okay. First time.
All right, yeah, we'll do that.
Thank you.
And then John Horton, did you want to make an announcement on that one?
Judge, as far as I'm aware, Mr. Horton is still suffering from severe mental illness. I do believe he's still on medications. I have not received any report that he's had to be forcibly medicated, and I'm still certain that we're waiting on a sterile state bed for him. But as far as I've heard, he's still not doing well.
Yeah, I have a notation that I believe Ms. Taberham got from Andrew Center, says that he has a follow-up at the Andrew Center on June 28th, and he's refused medication one time. So,
That sounds about right, Judge.
all right. So let's just set him for status. Let's just set him July 19th as well.
Yes, sir. Thank you. Is that show all my business with your court?
I do think so. I
think so as well.
Yes, sir. Thank you.
All right. Thank you.
All right, definitely. Make sure you're ready on.
It's 2:30. Are we ready for the interpreter?
Yes, Mr. Vargas just logged back in. All right, Mr. Vargas, you understand that you are still under oath to make a true translation in this case? Okay, I'm not going to put you back through that oath for this case, but it's already on the record. And so I'm going to give you a moment, let Ms. Taberham get you set up so that you can speak with the defendant to make sure that you have clear communication.
Let's see.
Excellent. Okay. And did you introduce yourself to, oh, you probably introduced yourself earlier because you spoke with him earlier over the lunch period. Is that right? Okay. All right. This is cause number CR 2237, State versus Jose Romero, Mejia Romero. And we are set for to enter a plea today. Is that correct, Mr. Manning?
Yes, Judge. And just by way of correction, his last name is, he informed me today that his last name is not spelled correctly. It's Romero instead of Romero. And we're unopposed to any request by the state to correct that.
Well, what's that going to do for our plea papers today?
And I believe that that is going to be an issue, Judge. Let me.
Is it a plea to time?
It's probation, Your Honor. But I still would prefer the paperwork to be correct, which means we would need to redo the judgment and the conditions of probation.
All right, Mr. Manning, if you'll just interlineate in the admonishments and the waiver of appeal, the Morton document, all of those, then we'll formally correct the judgment and the conditions of community supervision. Now, did I say his name correctly when I said Jose Romero? Is that Romero? Is that correct? Jose Romero.
As the interpreter explained it to me, his, I guess the way that anglicized a name would be pronounced as Jose Meja, and Romero is a familial name from his mother's side, I believe is the way it was explained to me.
Okay. All right. Does he have a middle name at all?
Emilio?
Emilio. Okay. All right. And Mr. Manning, can you tell me the terms of the plea agreement, or Ms. Heisel, whoever has it handy?
Judge, I can hear. Upon a plea of guilty to the state jail felony charge of PCS under a Graham PG1, the state is going to recommend punishment be assessed to 2 years, TDCJ, state jail division probated for a period of 4 years with a fine of $2,000, court costs of $290, restitution in the amount of $180, and reimbursements in the amount of $515. And Judge, I also am seeing that the jail does not have any back time credit for him, which obviously he's in custody. So let me also.
Well, that would, sorry, feedback. That should be reflected on the probation judgment. It would only be if he was.
That's right.
So,
That's right. Thank you, Judge.
Yeah, you're welcome. So, Mr. Manning is Mr. And you said it's Mejia
Romero.
Mejia Romero. Okay. And is Mr. Mejia Romero a United States citizen, Mr. Manning?
No.
Okay. And Mr. Manning has your client discussed the potential immigration consequences that could face him should he enter this plea today?
We have, Judge.
Okay. All right. Mr. Mejia Romero, if you'll raise your right hand, sir, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right. You may lower your hand. All right, sir, are you a United States citizen?
No.
Have you discussed the possible consequences that could affect your legal status in this country if you enter into a plea agreement today? Have you discussed that with an immigration attorney? And are you comfortable with proceeding in the plea today? And obviously, you have utilized the assistance of an interpreter in today's proceeding and throughout your case. Is that correct? And have you ever been diagnosed with any type of mental conditions?
No.
Have you been pleased with Mr. Manning's representation of you as your lawyer? Do you feel like you've had enough time to discuss your case with him and that you've had enough time to have all of your legal questions answered? Is there anything about the plea papers that you've read and signed and reviewed with your attorney and the interpreter that you do not understand?
No.
Okay, very well. All right, Mr. Romero, you are charged with a state jail felony offense of possession of a controlled substance in penalty group 1, less than 1 gram. This crime carries a range of punishment. If you were convicted and sentenced, the sentence would have to be within the minimum of 6 months in prison to the maximum of 2 years in prison. And also, you could receive a fine up to $10,000. Do you understand that full range of punishment?
Yes.
And do you also understand the plea agreement in this case is that today the court would assess your punishment at the maximum 2 years in prison, but the court would suspend that sentence and place you on community supervision or probation for 4 years. And if the court approves this plea agreement, you also understand that if you violate any of the conditions of your probation, you could be brought back before this court and evidence could be presented. And if the evidence proves to this court that you violated, your sentence of 2 years would then be imposed upon you. Do you understand that? Do you still wish to proceed? Okay, sir, then I'm going to ask you, how do you plead to the crime of possession of a controlled substance in penalty group 1, less than 1 gram? Guilty or not guilty?
Probably.
Are you pleading guilty to this crime because it's true that you are guilty of committing this crime?
See.
Has anyone threatened or forced you to plead guilty today, Mr. Mejia?
No.
All right, the court will accept the defendant's plea of guilt in this case. Mr. Manning, do you have any objection to States 1, the evidence in this case?
No objection to States 1.
All right, court does admit States Exhibit 1, the evidence in this case, and the court will take judicial notice of the defendant's judicial confession. Is there anything further from the state at this time?
No, Your Honor.
Anything further from the defense, Mr. Manning?
Yes, Judge, for record purposes, I'd like to note that we have received corrected judgment and probation paperwork with the name spelled correctly for Mr. Mejia Romero. And that is included in the paperwork that will be given to be fingerprinted on.
Great. I appreciate the DA staff for getting that done. All right, and can I have the facts to support the plea from the state?
Yes, Your Honor. The defendant was the single occupant in a vehicle that was pulled over in Wills Point for failing to keep right at the monument. Essentially, my understanding is instead of going right around the monument and then turning left after the monument, he turned left in front of the monument. They pulled him over. He was able to identify himself using a passport from another country. When they ran his name and information, it came back that he had a warrant from another state. They confirmed on that warrant and placed him into custody. As they were inventorying the vehicle for towing, they found a wallet in the vehicle. As they opened it to inventory the money inside, document the money inside, they noticed some crystalline shards stuck to a dollar bill inside the wallet, some loose, what they believe to be methamphetamine in the wallet. There was additionally a baggie containing crystalline substance. That baggie is what was sent to the lab to be tested, and it did come back as 0.41 grams of meth. The defendant did identify the wallet as his wallet after they found the drugs in it.
Thank you, Ms. Heisel. Any objection to that summary, Mr. Manning?
No, Judge.
All right, court will, based on the evidence, follow the plea agreement in this case. The court finds that there is sufficient evidence to convict Jose Romero of the offense of possession of a controlled substance in penalty group 1 less than 1 gram. Court will assess his punishment at 2 years confinement in the Texas Department of Criminal Justice. Court will suspend that sentence today and place the defendant on community supervision for 4 years. Order him to pay a $2,000 fine, $290 court cost, $180 restitution. Order him to pay reimburse Van Zandt County in the amount of $515. Mr. Mejia Romero, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. You're going to, in a moment, you will step over with the deputy to be fingerprinted. It's very important that when you report to probation, that you bring someone with you who can help translate and interpret for you so that you understand what your obligations are in this case. Do you understand?
And Your Honor, just if I may, I spoke to probation and they have someone over there who does is able to speak and communicate in Spanish a little bit to help communicate those conditions to him. We have explained them with the interpreter, each and every one of those conditions we went through in detail.
Okay, it's still advisable for him to bring someone in case that person's not there.
Correct.
And I know that's what the probation department wishes. So, all right, Mr. Romero, then step over to be fingerprinted with the deputy.
You're up, sir.
Here. Yes, that is all for this case, Mr. Vargas. I appreciate your assistance today. Yes, you may. Thank you so much. Tell your colleagues I said hello. Great day. All right, Mr. Steele, you ready on Mr. Cruz?
Yes, Judge.
All right, this is cause number CR 2214, CR 2212A, State versus Philip Sean Cruz. Cruz, if you'll raise your right hand, sir, I'm going to place you under oath. You swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, sir.
All right, you may put your hand down. Your name is Philip Sean Cruz, is that right?
Yes, sir.
And Mr. Cruz, are you a United States citizen?
Yes.
Do you read, write, speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Kyle Steele. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today with your attorney that you do not understand?
Yes, sir.
And Mr. Steele, do you believe your client to be competent today?
I do, Your Honor.
And you've explained to him his legal rights, and do you believe he understands them?
I have, Judge.
All right, Mr. Cruz, you are charged by indictment in CR 2214 with the third-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 1 gram but less than 4 grams. That does carry a range of punishment if convicted and sentenced to not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice, and the imposition of a possible fine up to $10,000. Do you understand that range of punishment?
Yes, sir.
I see here that there's a plea agreement wherein you would plead guilty to that charge. The state's recommendation is punishment to be set today and assessed today at 8 years confinement in TDC, with that sentence being suspended and you being placed on probation for 5 years, along with you paying fines, restitution, court costs, reimbursement fees, and the state would, to resolve other matters that you have pending, they would dismiss all of the cases that are represented in the terms of the plea agreement on the judgment, and there are many. And you've reviewed those, haven't you?
Yes, sir.
All right. So is that your understanding of the plea agreement, Mr. Cruz?
Yes, sir.
All right, then at this time, Mr. Cruz, I'm going to ask you, how do you plead to the offense charged?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened or forced you to plead guilty today?
No, sir.
Court will accept the defendant's plea of guilt. Mr. Steele, any objection to the state's evidence?
No objection, Judge.
State's evidence is admitted, and the court does take judicial notice of the defendant's judicial profession. Anything further from the state?
No, Your Honor, we would rest and close at this time.
Anything further from the defense, Mr. Steele?
Rest and close, Judge.
All right, court will review the evidence. All right, the court has reviewed the evidence, and I do find enough evidence to support this plea. The court will follow the plea agreement in this case. The court hereby convicts Philip Sean Cruz of possession of controlled substance in penalty group 1 greater than or equal to 1 gram less than 4 grams. Court assesses sentence pursuant to the plea agreement at 8 years confinement in the Texas Department of Criminal Justice. Court suspends that sentence, places Mr. Cruz on community supervision for a period of 5 years, orders him to pay a $1,500 fine, $180 restitution, $290 court costs, and $35 reimbursement fees. And the court does dismiss and take into consideration all of the causes of action that are listed in the terms of the plea bargain listed on the judgment of conviction by the court. Mr. Cruz, you understand that once you get on probation, you're required to comply with each and every one of your conditions of community supervision. You understand that, right?
Yes, sir.
And you've read over those today, and you've reviewed those with Mr. Steele, so you know what's expected of you, correct?
Yes, sir.
And you understand that if you violate any of those terms, the probation department could alert the state through its prosecutors. They could file a motion to revoke your community supervision. They could arrest you, bring you back for a hearing. And if they prove to the court that you violated, the court could take that evidence and use it to revoke your community supervision and impose the 8-year sentence that's hard, or can impose what's already been assessed today. You understand that?
Yes, sir.
So that means if you violate your conditions of community supervision, you go to prison for how long?
8 years.
8 years. Okay. All right. I just want to make sure we're on the same page. All right, then court hereby remands Mr. Cruz to the custody of the Van Zandt County Community Supervision and Corrections Department so they carry out the terms and conditions of the sentence. Step over with a deputy to be fingerprinted. and then the probation officers will give you more information.
Thank you, sir.
You're welcome.
Your Cruz's paperwork?
We ready on Mr. Watkins?
Yes, Judge.
Michael Watkins, CR 2201. All right, Mr. Watkins, if you'll raise your right hand, sir. You swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may lower your hand. Make sure you speak up loudly and clearly for me so that I can hear you and so my court reporter can take down everything we say, okay?
Yes, sir.
All right, Mr.
Judge, can I interrupt you? I was going to ask the court if they would entertain a continuance on this case. I have not been able to come down to the Van Zandt. I was in trial, then I was on vacation, and I have not been able to come down to talk to my client to go over all of the ups and downs and pitfalls of taking the plea. He, has indicated to me that he does not feel like he has been explained all of the paperwork or the situation that he's facing today, and he would like for me to go over his entire file, which includes the motion to revoke and all the allegations, of which I have not had an opportunity to come down here and talk to him. And so for my benefit, Judge, and for the court's benefit and for everybody's benefit, just make sure that my client intelligently takes his plea. I would ask that the court reset this for 30 days, and we will either have a contested hearing or we will take a plea that day if the court would allow that.
State.
Judge, state is unopposed. I want to make sure that Mr. Watkins fully understands what he's signing for. If he does, if Mr. Steele says that he doesn't believe he's had adequate time, state would be unopposed to providing him time to make those decisions such that we have a adequate knowledge of what he is accepting and agreeing to.
All right. Court would set Mr. Watkins then 9 a.m. on June 28th. That would be a contested docket date. If there's no agreement that day, then we'll just proceed with the hearing that morning.
Yes, sir.
And so that will be here in the courthouse in the
Yes,
morning,
Judge.
9 a.m.
Yes, Judge. Am I excused?
Yes, that's all.
All right, thank you.
Mr. Steele? There's two items. Yes, Mr. Cruz, come on back over here. Your Honor, I'm sorry, I need just a moment to gather my wits. Can I mute and see where we are, please?
Yes, ma'am, absolutely.
Thank you.
All right, Mr. Manning, who are you ready with?
Judge, we have Mr. Michael Scott Williams.
All right, this is cause number CR 21200. This is a motion to revoke.
Yes, Judge, we have a motion to withdraw, the motion to adjudicate and amend to include 60 days in the county jail as a condition of probation with credit for 27 days and a remainder of 33 days to be served.
Is he serving those continuously?
Yes, Judge.
And that'll begin today.
Yes, Judge.
All right, Mr. Williams, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you got.
Yes, Your Honor.
All right, put your hand down. Make sure you speak up a little bit louder for me.
Yes, sir.
Mr. Williams, you heard what Mr. Manning said to the court about your agreement with the state to for the state to amend your community supervision conditions, withdraw their motion to revoke, and to require you as a condition of your community supervision to serve 60 days in jail with you receiving credit for 27 of them and serving the remainder of 33 beginning today. Is that right? Is that what you heard?
Yes, Your Honor.
And that's what you are asking the court to approve today?
Yes, sir, Your Honor.
And has anyone threatened or forced or pressured you to enter into that agreement?
No, sir.
And are you pleased with Mr. Manning and his representation of you in this matter?
Oh, yes. Yes, sir.
All right. And Mr. Manning, you do believe Mr. Williams to be competent to enter into this kind of agreement?
He is, Judge.
Okay. And does Mr. Williams also understand that if he is subsequently revoked, that he will not receive any credit time for these 60 days because they will be served as a condition of his community supervision?
Yes, Judge, I explained that to him.
Yes, sir.
All right, court will approve the agreement between the defendant and the state. Court will amend, the court will grant the state's motion to withdraw its motion to revoke. The court will amend Michael Scott Williams' community supervision conditions to include 60 days confinement in the Van Zandt County Jail as a condition of community supervision. The court will give him 27 days credit towards that 60-day sentence or imposition of community supervision condition, and will order him to serve the remaining 33 days beginning this date. Court will sign that and will be adjourned. And Mr. Williams, I hope that this is the last time that you come through. If you want to be on community supervision, then you're going to have to do what you're ordered to do.
Yes,
I doubt next time will be as light of a sentence as what you've received today.
Sir.
All right, so be thankful to Mr. Manning. We'll be adjourned.
Judge, and just if I may, procedurally, it looks like I picked up the motion to withdraw that was part of the plea paperwork packets that I grabbed. I don't know if the state has provided Judge another copy to sign.
Jonathan, if you'll just put it with the rest of the plea paperwork to be brought back to the courthouse, I'll make sure it's signed at the courthouse after this hearing.
Excellent. Judge, we're also ready on Mr. Alejandro Garza.
Okay, we can proceed. All right, this is cause number CR 21216, set for arraignment. Are you ready for arraignment, Mr. Manning?
Judge, we waive arraignment. His name is spelled correctly. He understands the charge against him, and we're ready to proceed on his plea of guilty to the offense.
All right, the court will find that Mr. Garza has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record and set pre-trial. Do you have a requested date, Mr. Manning?
Judge, we're entering a plea of guilty and proceeding on a plea.
Oh, on the arraignment today?
Yes, Judge.
Okay, I'm sorry. I thought you said you were waiving that. You're going to plea of not guilty. All right, so what are the terms of the plea agreement?
Judge, there's me a deferred probation for a period of 3 years, a fine of $2,000, and $180 restitution. Sorry, it's a little warm in here, Judge.
I understand. Is it 180 degrees in there?
It feels like it.
What's let's see, any reimbursement?
Yes, Judge. Reimbursement of $585 and court costs in the amount of $290.
All right, Mr. Garza, if you'll raise your right hand, sir, I'm going to place you under oath. Mr. Garza, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Your name is Alejandro Garza, is that right?
Yes, sir.
Mr. Garza, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you?
Yes, sir.
Feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed today with Mr. Manning that you do not understand?
No, sir.
All right, Mr. Manning, do you believe your client to be competent today?
He is, Judge.
And have you explained to him the advantages and disadvantages of a deferred adjudication plea in addition to his legal rights?
I have, Judge.
And do you believe he understands all of those?
He does.
All right, Mr. Garza, you are charged by indictment with a state jail felony offense of possession of controlled substance in penalty group 1, less than 1 gram. That offense carries a range of punishment if convicted and sentenced to not less than 6 months in prison or more than 2 years in prison, and possible fine not to exceed $10,000. Do you understand the potential range of punishment?
Yes, sir.
All right, understanding the plea agreement and the range of punishment at this time, Mr. Garza, how do you plead to that offense? You plead guilty or not guilty?
Guilty.
Are you pleading guilty to that crime, Mr. Garza, because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened or forced you to plead guilty today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Manning, any objection to States 1?
No objection.
States 1 is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we had rest and close at this time.
From the defense?
Nothing from defense.
All right, state, can you give me the facts to support the plea?
Yes, Your Honor. On the date in question, the defendant is pulled over by the Texas Highway Patrol for a misplaced unreadable license plate, changing a lane while unsafe and following too closely. The trooper detects signs of nervousness and criminal activity. The Highway Patrol asks for consent to search the car and defendant, which he gives, and during a pat down, Highway Patrol finds 0.2 grams of meth in 2 baggies in his shirt pocket.
Thank you, Mr. Woodley. Mr. Manning, any objections or additions or deletions?
No, Your Honor.
All right, then based on the evidence presented, the court finds that there is sufficient evidence to convict Mr. Garza of this offense. The court will, however, follow the plea agreement reached between the defendant and the state. The court hereby defers a finding of guilt for Mr. Garza, places him on deferred community supervision for a period of 3 years, orders him to pay a $2,000 fine, $180 restitution, $290 court cost, and $585 reimbursement fees. Mr. Garza, you understand that with you being placed on community supervision, that if you violate any of the terms and conditions of your community supervision that you've read over today with Mr. Manning, you understand that the state's attorneys can bring you back before the court and put on evidence. And if they prove to the court that you violated your community supervision, they can ask the court to revoke your community supervision, to adjudicate your guilt. That means to convict you of this offense and assess your punishment anywhere between that minimum of 6 months to that maximum of 2 years. You understand that?
Yes, sir.
Okay. All right, Mr. Garza, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of your sentence. I'll have you step over with Deputy McLeish to be fingerprinted, and then the probation officers will give you more information.
See you? Yes. Okay. Judge, we're ready on Miss Jennifer Gonzalez.
All right, Jennifer Lynn Gonzalez, CR 2166. All right, is this going to be an arraignment or plea? What are we doing today, Ms. Gonzalez?
Judge, this is just me an arraignment. I have not been given the discovery in this case, but I believe I was just appointed. Sorry about that. I was just appointed on this case recently, and at the time that I was appointed, it was unindicted. Judge, we've had a chance to review the indictment. My client understands the charge against her. She understands the range of punishment. Her name is spelled correctly at this time. I plead not guilty and request pretrial setting.
All right, court will enter Ms. Gonzalez's plea of not guilty into the record. Court will set this matter for pretrial. And what date did you want, Mr. Renee?
Judge, I believe you were resetting those to July 5th.
5th, 7th, 19th, 21st. Yeah, any of those. You want 5th?
Judge, if we can.
All right, court will set Ms. Gonzalez then for pretrial hearing on July 5th at 1:30. If she's in jail, Ms. Gonzalez, if you make bail in this case, then your hearings will be at 9 a.m. in the courthouse on that same day.
Yes.
I'm ready, Mr. Meany.
Judge, we're ready on Mr. Kyle Casey.
All right, this is cause number CR 17222, motion to revoke. Go ahead, Mr. Meany.
Judge, we have received the discovery in this case, and we request at this time to be set on a contested docket to hear the motion to revoke.
Okay, court will set Mr. Casey for contested hearing the morning of June 28th at 9 a.m.
No. How you doing, Mr. Boyd?
Good afternoon, sir. How are you? You're Mr.
All
Boylan,
right.
right? You're Mr.
Yes,
Boylan.
sir.
All right, this is cause number CR 2288, set for pretrial, Mr. Manning.
Yes, Judge. My understanding from the communication I received from the DA's office is that there are additional charges that have been added on. I've received a discovery on the failure to comply, but not received a discovery on the additional MO requests that be reset on pretrial for us to gather the information on all those cases and handle them together.
Do we know if the other cases have any settings at this time?
Your Honor, we just indicted them Friday, so I suspect that they do not yet have settings. Mr. Manning, I believe I tried my best to share discovery on all of the new cases yesterday with you. So if you would just recheck your portal, and then Judge, obviously, if we could have these all set over together, but I'm not sure whether arraignment has been set on the new charges or not.
I don't believe they have. Okay. All right. So give me just one moment. Let me consult Ms. Abraham, and she'll probably know off the top of her head what date she intends to set those for arraignment, and I'll go ahead and find that date and put it together. So give me just 1 second.
Just a second.
Mr. Manning's first witness on the record, Thomas Logan Bailey, Mr. Green, filed a motion to list statements unopposed.
Judge, I'm not sure if you're muted or not, but we can hear you.
Sorry. Microphone wasn't on all the way. So for the record, Mr. Green had filed motions for continuance. State was unopposed. Court had set both of those on June 14th.
Yes, Judge, thank you.
All right, Mr. Manning, Ms. Abraham says you'd probably set those new indictments for arraignment on either July 5th or 7th. So if one of those is more preferable than another.
We can do July 5th, Judge.
All right, court will reset Mr. Boylan then for pretrial on July 5th. That will be at 1:30.
And Judge, do you want me to include those new case numbers on this reset notice, or is Ms. Abraham going to docket those separately?
She will docket those separately, but I'll tell you what, let me go ahead and give you those new numbers. If you don't have them with you, I'll tell you what they are. It would be CR 22-167 168, 169, and 170. All right, also for the record, cause number CR 21366, Mr. Ashmore filed a motion for continuance on Tamara Lee Ream. Is Miss Ream in the courtroom at all?
She is, Your Honor. Come
Oh,
on.
come on, Miss Ream. Ms. Ream, your attorney, Mr. Ashmore, filed a motion for continuance citing his unavailability for today. State was unopposed to the motion. The court has granted the continuance. I'm going to reset you, and I'll tell you what, I'll reset you to week after next. Okay, so it won't be a long reset. I'll reset you until, you know, I'm not sure if Mr. Ashmore is going to be available on either one of these dates, but we're going to set you for Tuesday, June 14th.
Thank you.
You're welcome.
Thank you.
Your Honor.
So we'll need Rochelle Shelton.
Yes, sir. I understand Mr. Manning is working on some paperwork
Okay.
before he's ready.
And then you said Mr. Manning wants Mr. Graves brought up, Devontae Graves.
And he just stepped in the room. Yes, Your Honor. They're both here now.
Okay. All right, this is cause number CR 22165, State versus David Anthony Devontae Graves. And I believe it was set for arraignment or plea agreement today. I have recused on this case. So, Mr. Manning, I believe you wanted to have an opportunity to make an announcement on the record.
Yes, Judge, just at this time, we have not received the order of recusal yet, nor the order appointing the new judge. I understand, I believe it's to be Judge Griffith. And I was just gonna see if we could get a date set certain for when Judge Griffith would be available for that plea.
Yes, and so what I'm going to do is I'm going to share with my screen with you to show you the order, just so. Let's see, it's the Honorable Senator Griffith. So if the parties will contact Ms. Abraham and just indicate what the action of the parties will be, the dates that you want, then she can confer with Judge Griffith to determine his availability.
And did Judge Griffith have a conflict today, or is there a reason why he was unavailable today?
I'm going to let the state address that.
Yes, the state asked for this to be reset off today's docket because we did not have the stipulation of evidence prepared. We now have the lead officer's report. And so at any point that both Judge Griffith and defense counsel are ready to proceed, I do believe we have what we need now to proceed with that plea.
Excellent.
So what I can do, Mr. Manning, is, we can set this on one of the regular dates and then consult Judge Griffith and move it if we need to. Is there a certain date that you want?
Judge, I'll be fine if it's all right with the court. I'll contact Ms. Taberham this afternoon, as well as the state, and see if we can locate a date that will be good for all parties.
Okay, very well.
Thank you, Judge.
You're welcome. All right, so Mr. Manning still needs time with Ms. Shelton.
Yes, Your Honor.
Okay, is there anyone else that?
Yes, Your Honor, I do have Thomas Bailey in here. I heard you speaking about Mr. Green just a moment ago. Do I just need to give Mr. Bailey a reset, or would you like to visit with him?
No, you can just let him know that his attorney requested a reset in this case due to his unavailability. He's in court in Henderson County, so he asked for it to be reset, and so we reset it to week after next on June 14th.
Very good. He heard you, and I'll give him a reset notice as
Oh,
well.
okay. Well, I'm sorry. I didn't know he was in there, so otherwise, sorry about that, Mr. Bailey. I would have told you myself.
Thank you, Judge.
Okay.
We'll get your signature right here.
Thank you, Judge. I appreciate
Hey,
it.
yeah, you're welcome. Sorry, I thought you were back in the back, so I was gonna not bother to bring you up and just to tell you that. So, yeah, Mr. Green is in court in Henderson County, so he's unable to be here.
All right. Y'all have a good one.
You too, sir.
I'll wait on him.
Your trustee.
I believe there's also CR 2279, CR 2282. Put this on the record. Isaiah Everett Smith was set for arraignment. Appears that he is still in the TDC Middleton unit. And looks like we're going to need to reset for a bench warrant. So I believe that we have set that for arraignment on July 7th. So I guess if there is a request for a bench warrant, that will need to come in well prior to that July 7th. So we'll just stand in recess, give Mr. Meany an opportunity to speak with Ms. Shelton, and then I believe that will be our final case of the day.
Judge, did Mr. Wilson waive arraignment on Mr. Eddington?
I do believe he did. I'll tell you. I believe. I know that he did. I signed that earlier. Is it still showing on your docket?
It shows on the docket that Ms. Abraham provided this morning, but
I see it now. June 14th. Pretrial set June 14th.
and same with Mr. Stevens and Mr. Hodges.
Yes, Ms. Stevens filed a waiver of arraignment for Justin Hodges. Pretrial set July 19th.
Thank you, Judge.
Because we have something.
Mr. Manning, are you ready on Ms. Shelton?
Yes, Judge.
All right, this is cause number CR 18337, State of Texas versus Rochelle Renee Shelton. State's prosecutor's moment to zoom in.
Sorry, Judge, I'm here.
That's okay, no problem. All right, Ms. Shelton, court made a mistake during your hearing, and I should have provided you with the opportunity to plead either true or not true to the counts alleged against you in the motion to revoke. In our last hearing, which was held on May 26th, on that contested docket date, we discussed whether or not you've reviewed it. We discussed if you had enough time with Mr. Manning, and then we went through a contested hearing. However, it was incumbent upon the court to provide you with the opportunity to either plead true or not true to those counts. So the court, I realized my mistake shortly thereafter the hearing, and I contacted your attorney, Mr. Manning, and also the attorneys from the state. And the state had filed a motion for rehearing, and the court had granted that, and that's why we are back on the record here today. So it's really just a mere formality, but it's something that I believe to be important. And it's an important right that you have. So I'm going to walk back through this process a little bit, and it's my understanding that the state's going to reoffer the same evidence. I asked the court to take judicial notice of the evidence that it received on May 26th of 2022. Before I go through all of that, Mr. Manning, do you have any objections or any issues that we need to address?
Judge, at this time, I haven't seen the final judgment to be able to examine that, to know if it is correct and accurate in terms of jail time credit, in terms of the sentence and range and degree. But other than that, I understand the procedure. I've explained the procedure to Ms. Shelton. And we're ready to proceed with this rehearing.
Okay, and I'll tell you what. Let's just do this. Let me show you the best. Really, the only way I can do it is, I don't know if you have it on your screen, Ms. Heisel, but I'll show you the judgment that I reviewed the other day when I caught my mistake. It did mention 102 days credit. Now that was on the 26th. Obviously, Ms. Shelton would get any additional credit from that date until yesterday. And then the credit she gets today would be picked up by TDC. So I'm just going to take a moment and just hold that up there and give y'all an opportunity to kind of read through it. And I'll try to keep this. Let me get still here. And Mr. Man, you just tell me when you want me to move up, and I'll do so.
Judge, I'm trying to see if I can get it blown up full screen. Hold on 1 second.
Yeah, and I wish I had this scanned into my system and I could share a screen, but unfortunately I can't. I'll tell you what, do this. If you're on a gallery view, just hit right click on my picture and say pin, and it should make that blow up for you.
Ah, there it is. That's been changed. Safety code, Judge, at this time, our plea is still going to be not true on the plea to motion for the motion to revoke.
Okay. So here you'll also see the credit time issues.
Let's say 3 years.
2 years. Judge, it's a little bit blurry, but just to confirm, there it is. Thank you, Judge.
You're welcome.
2 years. That's not fine.
What do I pay that?
How do you pay that over?
When I get out.
Also going to share. Two balances, but that and that. Judge. 2 days plus whatever days we have.
Is that open?
Judge, we were able to complete reading that.
Okay, that was page 1, and then Do you need to see page 2? I don't know that it provides you any information other than the counts that were alleged here. And then the imposition of the balance of financial fine.
Okay, Judge, thank you.
Thank you.
All right, so what we're gonna do is I'm just gonna we're gonna go right back through that same process that we began a little bit the other day. So Ms. Shelton, if you'll raise your right hand, ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you got it.
Yes.
All right, you may put your hand down. All right, so Ms. Shelton, are you pleased with Mr. Manning's representation of you?
Yes, Your Honor.
Do you feel like you've had enough time to review the state's motion to revoke with him, have all of your legal questions answered?
Yes, sir.
All right, Mr. Manning, do you believe your client is competent today?
She is, Judge.
Okay, and Mr. Manning, have you and Ms. Shelton reviewed the state's motion to revoke community supervision? And if you need me to display that, I'd be happy to do so. If you don't have a copy with you, do you have a copy with you?
Judge, we reviewed it in preparation for the motion to revoke hearing that was held on the 26th, and we've had plenty of time to review that and prepare for it.
Okay, and it's my understanding that your client intends to plead not true to all counts, which are counts 1 through 9 as alleged in the motion. Is that correct?
That is correct, Judge.
Okay. All right. So, Ms. Shelton, you appeared before the court on October 26, 2021. You pled guilty and you were convicted pursuant to a plea agreement of the offense of possession of a controlled substance in penalty group 1, less than 1 gram, a state jail felony. The court heard the evidence, followed the recommendation of the agreement, and the court assessed your punishment at 2 years confinement in the state jail division of TDC, and also assessed a $1,000 fine. The court then, pursuant to the plea agreement, suspended that sentence and placed you on community supervision for a period of 2 years. And it was during that period that the state filed its motion to revoke your community supervision. So, having had ample time to review that with your attorney, at this time, Ms. Shelton, I'm going to ask you, how do you plead to counts 1 through 9? Are those counts true or not true?
Not true, sir.
And as I recall from the 26th, there was no agreement as to recommendation on any type of sentence. And on the 26th, the court allowed the state and defense to put on evidence. So at this time, Ms. Heisel, I'm going to ask you to put on your evidence at this time.
Your Honor, at this time, the state would ask you to take judicial notice of the previous proceedings as the state's evidence in this hearing.
Any objection, Mr. Mayor?
Sorry, Judge.
Any objection?
No, Judge.
All right, court will take judicial notice of all evidence received by the court in this matter now on trial, received by the court on May 26, 2022. State have any additional evidence or witnesses?
No, Your Honor, state would rest.
All right, Mr. Manning, present you with the same opportunity to present any evidence on behalf of Ms. Shelton at this time.
Yes, Judge, we would reoffer the testimony and evidence that was offered on the May 26th hearing and renew our request for a plea, or for a sentence less than the maximum in this case.
And Ms. Heisel, any objection?
No objection, Your Honor.
All right, the court will admit all evidence received by the court on May 26, 2022. The court will take judicial notice of that. The court will consider the defense request on the sentencing. Anything further from the defense?
Nothing from defense.
Anything further from the state, Ms. Heisel?
No, Your Honor.
All right, based on the evidence presented both on May 26th and re-admitted and considered by the court today, court hereby finds that Ms. Shelton has pled not true to all counts alleged in the state's motion to revoke. Court will find that Ms. Shelton has violated the terms and conditions of her community supervision. Court will revoke her community supervision and assess her punishment at 2 years confinement in the Texas Department of Criminal Justice State Jail Division. Court will order her to pay the balance of her financial obligations. The court will issue her credit towards her sentence for the time that she has spent in jail on this cause. And I believe that that would be 108 days credit. And the court hereby remands Ms. Shelton to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Ms. Shelton, the court will have a judgment provided to the jail, and at some point, someone's going to come and take a fingerprint of you for that judgment. Ms. Heisel, when I don't believe that we have the preparation of the new judgment, but when we do have that, will you provide that to Mr. Manning?
Absolutely, sir.
And then,
Judge, if we may also just make sure that we have an extra copy of the judgment that's been signed by the court so that she can have that for her records and transport down to TDC.
yes, I will ask that a copy be made of the judgment once it's signed by the court and then provided to Ms. Shelton.
And Judge, what was the credit time on the original judgment?
102 days.
Okay.
So I counted, that'd be 1, 2, 3, 4, 5, 6, 7, 8. The credit time would go up through to yesterday, and then today's would be picked up by TDC in their calculation. So,
Yes, Your Honor. I started with the wrong number, so I will correct that and then get the judgment sent over to everyone.
okay. Once we get that, we'll send it out to the jail, and I will get you a copy of Michelle.
Judge, the concern is that Ms. Shelton is currently housed in Henderson County. And so I don't know if procedurally if we'll be able to get that done today, or if we will have to send that down to.
I'll ask Ms. Taberham to notify Lieutenant Harrelson not to send Ms. Shelton back until we get the fingerprint and work out the paperwork.
Thank you, Judge.
All right. Anything further, Mr. Manning?
That concludes our business. May I be excused?
Yes, thank you, Mr. Manning. Thank you, Ms. Shelton. Sorry for the confusion on that.
That's okay, thank you.
You're welcome. Thank you, Ms. Heisel.
Thank you, Judge. May I be excused?
Yes, ma'am. And if you'll just send that over, we'll make that communication to Lieutenant Harrelson. If you'll just send that over to Patty, when you send it over to Jonathan, then we'll go ahead and get her fingerprinted ASAP.
Okay, thank you, Judge.
All right, thank you. Appreciate you.